If you're not familiar with a severance agreement, it's an agreement your employer will give you when you're heading out the door. And usually employers want to give that so that they can be sure you're not going to sue them. It's money they offer in exchange for you not suing them after they, terminate you or you resign. And with those, the reason you want to talk to an employment attorney before you sign one of those, one, they're going to be written by the company's lawyers. So they're going to be heavily drafted in the company's favor. Two, you want to make sure, basically that you're not getting screwed over by the contract, you want to evaluate it. First you want to evaluate to see if you got any potential claims on your way out the door. And if you have potential claims, then the value of that severance agreement shoots way up because they got to pay you off, because you got a valid lawsuit you can bring. So you got to take that into consideration. And two, you also want to make sure, if there's a provision, like they can claw back any of that money or they can bring you back on, after, you separate from employment. You want to make sure you're compensated for that, you want to make sure they can't, after, you separate from employment, you want to make sure you're compensated for that, you want to make sure they can't go out and attack your name after you leave, stuff like that. There's a lot of stuff, you want to look for in those severance agreements. That's why you should have a attorney review one before you just sign it. A lot of people get into situations where they're leaving a job, they don't know what they're going to do. Usually it's unexpected. They don't know what they're going to do. They don't have another job lined up. And the company is just throwing money at you, so they try to rush you into signing it, before you take a second and actually, get your bearings and look at it. They don't want you to have a clear head when you look at it. Now, when it comes to signing the severance agreement, if you're 40 or over, they're required to give you at least 21 days to review that agreement. If you're under 40, there's no requirement that they give you any time at all, but usually they do, and usually the severance agreement will, it will say that, hey, there'll be some language in there that says you had an opportunity to have it reviewed by an attorney. They want that in there because it makes it stronger on their behalf, but they really don't want you looking at having an attorney look at it. Most of them don't. They just want to be able to say that they offered you that opportunity, Like I said, these agreements are typically drafted heavily in their favor. So, any changes to it, sometimes they're going to be reluctant to that. But the more, like I said, if you have a claim against them or evidence that would support a claim against them, that makes the value of that agreement goes up. That's something that you can use as leverage to negotiate for more money. And other things, had clients before who, they were sick or their spouse was sick and they needed more, longer medical coverage. That's something you can negotiate for as well. It sort of varies by company, but, payment of bonuses, all that stuff you want to have reviewed before you just sign away your agreement. Say like if you have part of your compensation is bonuses, you want an attorney to look at, your actual employment agreement or the bonus program to see if that's something you're entitled to, if that's something that should be even on the table when you're negotiating a severance. A lot of times employers will like to include, they'll say, well, hey, we'll pay you that bonus, as part of this severance. And, depending on how the contract language was written, you may already be entitled to that bonus. So that's not even something that should be in the discussion at all, because you had already earned that and you should already be entitled to that. That should be included in your compensation, regardless if you remain at the company or not, So, yeah, employers like to get slick with it, but you need someone who understands the law, understands what you're owed under the law, and you know, who's going to negotiate on your behalf. And there's various ways to do that. I like to gauge and see how litigious an employer is before I, you know, actually make my presence known. Some companies, because I said they, you know, they like to control things. They want to dig their heels in if they know you got an attorney. Like I said, they don't like for you to get an attorney to negotiate, you know, severance or, you know, agreements, or for any matter, you know, any sort of claim you have for that matter. So, you know, in those situations, I sort of guide a client from the background, what to do, what to say. I may draft emails on their behalf and just have them send it. And communication is sort of filtered through me. Well, they're given directly to the employee and they give them to me, and we sort of, you know, draft, you know, crafted response. You know, that's one way of doing negotiations. Also, you know, sometimes I'm upfront, you know, I'm comfortable either way, but I always try to, my perspective is what's best for the client, you know, what's going to be, what can they handle, you know, how much risk are they comfortable with? Because, you know, oftentimes, you know, you're not guaranteed a severance to begin with. Your at-will employee, they don't have to give you a severance. You know, they want to because they don't want you coming back and suing them, but you're not obligated to receive a severance. You know, and just because they did it for someone else doesn't necessarily mean they got to do that for you. Just because they paid someone X amount of dollars doesn't mean that they're going to pay you X amount of dollars as well. You know, each case is different. You know, so that's something you want to look at, or, you know, have an attorney examine for you before you just go out and sign these things.